Welcome to the third session of our course, The Law of Philosophical Aspects, this time about judicial review and majoritarianism. So the topic of judicial review, of which I'm sure you've heard before in many different contexts, at the very least raises some democratic discomfort. The feeling that the thought that courts should be able to somehow strike down legislation by the majority in the legislature, in the representative body, at the very least leaves some unease. And so we want to see if we can clarify that discomfort in a more robust and careful kind of way. You may even think that judicial review, at least of legislation, is undemocratic or perhaps elitist or in some contexts people would say dictatorial. But really, once you get into it, it becomes anything but obvious what exactly the worry is, what the problems with the judicial review are supposed to be exactly, how they are to be fleshed out, and whether either judicial review or its rejection can withstand critical reflection. Indeed, once you get into the topic, you may find it necessary to get deeper in. It may be the case that the fate of judicial review should be decided only with a clearer view of the fate of democracy and majoritarianism more generally. Why it is that democracy and majoritarianism matter, how it is that they matter, if indeed they do, and so on. So this is what we're going to be doing here. We're going to try to clarify the worries about judicial review, at least some central worries. We're going to try to think about arguments for judicial review, and we're going to place the discussion in the somewhat wider political philosophy context of discussions of the justification of democracy and majoritarianism. Okay, so we need a few clarificatory points here. What is it that we're talking about when we're talking about judicial review? One thing that we're not going to be talking about, or anyway not focusing on, is the court, a single court or the courts in general, authority to review the administration, to review actions by the executive branch. This is something that courts do all the time, and that at least from the point of view of constitutional theory, or even from the point of view of political philosophy, is not in any serious way problematic. Certainly no problems about democracy come up here. I do want to note, though, that even though questions about the court's review of the administration, even though they're not that theoretically interesting, they may be politically interesting, and they may indeed be politically dangerous. In many places, certainly in the country where I'm coming from, much of the fire that's directed at courts, much of the criticism of courts, much of the claims about courts or the Supreme Court's so-called judicial activism, much of it comes not because of the very few cases in which the Supreme Court has struck down legislation, but because of many more cases in which the court has reviewed the administration's actions. So if you want to focus on what makes most difference practically, it's quite possible that this is what we should be talking about. But this is mostly a theoretical course, and from a theoretical point of view, the court's authority to review the administration is not that interesting, really. So we're going to be focusing rather on the court's authority or purported authority to review legislation, to review actions by parliament, and in particular, perhaps to strike them down, at least sometimes, because they are unconstitutional. Now here too we need a few distinctions. One distinction is that between procedural and substantive reasons for striking down a piece of legislation. Sometimes a court may strike down a piece of legislation perhaps because it didn't go through all of the right moves in Parliament, based on the Parliament's own rules and modus operandi. This kind of judicial review is important and interesting. Sometimes it can be politically significant, but we are going to set it to one side, at least for the most part of our discussion. Rather, we're going to be focusing more on the cases of judicial review based on substantive considerations. So procedure to one side now. Should also be acknowledged that there really is no one uniform phenomenon called judicial review. Judicial review has many different shapes, and it takes different shapes in different jurisdictions, in different times, in different contexts. So I just want to highlight some of these differences and then to avoid discussing them for the most part. One important distinction is what exactly is the court authorized to do when it is reviewing legislation. Perhaps at the extreme, the court may be able to strike it down, to declare a piece of legislation unconstitutional and so void. But this is not, although this is without a question, the sexiest form of judicial review. It is in no way the only way of judicial review, and we know from other jurisdictions and other traditions, other forms of judicial review. Perhaps, for instance, the court has merely the authority to point out that a piece of legislation is problematic, at least purportedly unconstitutional, and then to return it to Parliament for further review. And there may be other options as well. So this is just along the dimension of the strength of the review. We have at least this distinction between two and maybe more options. Another important question is who or which institution has the authority to engage in judicial review. And there are many options here. So one option would be to have a special constitutional court, in some cases even a special constitutional court whose judges are appointed in a special procedure. Perhaps they are closer to another chamber of parliament in some respects. Or you may think that the authority to judicial review should reside with the normal Supreme Court. But then we need to talk, of course, about the judges there, how they are appointed, and so on. Or you may think that the power to engage in judicial review of even primary legislation should reside with any court whatsoever, so long as a case comes up when the constitutionality of a piece of legislation is relevant. And there may be other options as well. Yet another important distinction, sort of within the set of cases in which judicial review may be relevant, are questions about how wide are the substantive grounds that call for judicial review. Perhaps a part of it can be what's written in the Constitution about judicial review, or perhaps in some precedents. But another possibility is that what determines how wide the scope of considerations that allow for judicial review is something like constitutional custom, or maybe some kind of internal, unenforced judicial restraint. And there may be other options here as well. So as I already said, for the most part, we're going to be ignoring these complications. And when we just need to focus our attention on a way of doing judicial review, we're going to focus our attention on a Supreme Court engaging in judicial review with the possibility of striking down a piece of legislation. But as I hope you can see, when we're going to be discussing justifications for judicial review and possible objections to judicial review, the discussion of the details may be relevant. It may be the case that some forms of judicial review are justifiable and others aren't. For instance, it seems much easier to justify a form of judicial review that merely allows the court to return the case to Parliament than a form of judicial review that allows the court to strike down a piece of legislation. Now, going in the opposite direction, it's possible that what arguments we will find plausible will depend on the kind of judicial review we have in mind. So with that in mind, we're going to set it aside and focus on the clearest, strongest case. Now, what exactly is supposed to be the problem? So as I said, judicial review, as you'll see later on, I'm not as suspicious of judicial review as some others. However, I agree that there is a suspicion. So we're trying now to diagnose the suspicion. What exactly is the suspicion there? I don't think it's primarily about judicial activism, roughly the thought that judges do too much, that instead of just calling balls and strikes, as it's sometimes put in baseball lingo, what they do is take on a more active role. I don't think that's the main thing because, as I already said, at least the main location for worries about activism really has nothing to do with judicial review of primary legislation. It's primarily about judicial review of the administration, which is a different topic and not a really profound one from a democratic theory point of view. So I don't think that's the main concern. You may think that what's going on with judicial review of legislation is not just that it's activism, but that it's judicial activism of a specific kind, perhaps a specific, more hard to justify kind. Now that's a possibility, of course, but notice, keep your eye on the ball, as it were. We're doing a lot of baseball here today. If that's the worry, if the worry is that it's an especially problematic, hard to justify kind of judicial activism, then the question immediately arises, well, what is so special about this kind of activism compared to others? And then as far as I can see, we're pretty much back where we started, trying to highlight special problems with judicial review. So I don't think the talk of judicial activism is going to be very helpful here. You may worry, some people certainly, some politicians clearly speak in this way, as if the problem is that judges may become too political, or maybe just become politicians. But I don't think that's a very promising way of looking at the worry about judicial review either, for the following two reasons. The first one is that merely by engaging in fairly rare and somewhat restrained constitutional review of primary legislation, judges do not immediately become politicians. This is just a terrible hyperbole. And on the other hand, it's not as if they haven't been doing any politics at all, that they are, to an extent, engaged in at least what can be thought of fairly widely, political action. So it's not like they've been entirely free of politics, and it's not like they immediately become party members by engaging in judicial review. So I don't think that's the right way to think about the initial suspicion or worry vis-a-vis judicial review. Here's another really important point. Some people talk as if the problem with judicial review is that it's undemocratic in a kind of definitional way. It's the very definition of democracy that so-and-so, presumably one person, one vote, or maybe majority rule, or something along these lines. And then, here's the problem with judicial review. It violates democracy thus defined, or thus understood. But that can't be what we're worried about, because what you are worried about, what you should be worried about always, at least when you do philosophy, but almost always in general, is not how you say it, but what you say, right? The important question now is not how to use the word democracy, or whether we can describe judicial review as democratic or not. The important question is whether to engage in judicial review, or whether to support institutional design that allows for judicial review. These are the important questions. And then if you don't want to use the word democracy for it, I'm okay if you use the word democracy star, or some other word entirely. It's about what we say. It's not about how we say it. So definitions can't be what does the work here. What may be doing the work is something deeper. It's not about the word democracy. Rather, it's about why it is that we care about democracy to begin with. It's about the values or normative considerations and constraints that underlie our concern about democracy. And with that in mind, now we can ask whether the best understanding of democracy or the best understanding of the values underlying democracy supports or perhaps is in tension with the practice of judicial review. It's not about the word democracy, it's about the normative considerations that it's supposed to be about. And so there's going to be more of that in what's to come. I want to sort of pause for a methodological point just for a couple of minutes. In legal discussions, it's very, very important to ask where the burden of proof lies. Right? It's a kind of a default position. If no one successfully makes their case, then the party that wins is the party that did not have the burden of proof, that did not have to prove anything. You may ask a similar question for theoretical discussions as well. So we will be presenting, here following the literature, arguments on both sides. Arguments that are meant to capture what's problematic about judicial review, but also arguments that are meant to justify judicial review, perhaps even say that it's required, that it's a necessary part of a just system of government. What if no argument escapes criticism? Well, no argument will escape criticism because that's the business, right? We're in the business of criticizing, critically evaluating arguments. But what if no arguments at the end of the day emerges successful after the critical evaluation? Well, then it seems like the party that should win is the party that did not have the burden of proof. So that's one plausible way of thinking about things here, at least initially plausible. It's about the default position. But the burden of proof, or if we're going to be somewhat more realistic in philosophical context, the burden of argument, it's not easy to place the burden of argument in philosophical discussions, and it's not really easy to see how helpful it is. Because at the end of the day, perhaps unlike in legal procedures, what we're looking for is the overall best theory, the one that perhaps answers in the most plausible way to all of our concerns. It's not clear that procedural or semi-procedural considerations about the burden of proof or the burden of argument can be very helpful here. So one possibility is that the default position is symmetrical. If no argument escapes criticism, we should just settle for saying that we don't know what the moral status of judicial review is, or perhaps even that there is no answer to the question whether judicial review is justified or not. It's just somewhere in a limbo state in the middle. That's a possible way to go. Or perhaps, and that's something that I'm going to want to return to a little later on, perhaps something of the initial worry about majoritarianism and democracy, perhaps something about that initial worry survives, if not as an all-out argument against judicial review, at least as a reason to place the burden of proof on those who attempt to justify judicial review. So perhaps the thought is, look, we're doing democracy, we're doing majority rule. Unless you have a good reason to go with judicial review, we're going with the legislature. And I'm going to want to come back to the thought that maybe at least as a defense of a weak default position, something about majoritarianism and democracy can still succeed. Okay, then let's start with the arguments. And these are going to be arguments. I'm going to start with arguments against judicial review, and then I'm going to go to arguments for judicial review. And I want to make a few general comments here. The first one is that, as in many, many other cases where what we're discussing is institutional design, and this is really what we're doing when we're asking about judicial review, the questions are always comparative. So this is not a case where we're asking, is it a good idea if the state has the authority to do something or not? It's pretty much given that we are in the territory in which the state has authority to proceed. The question is, which state institution or which state organ will have that authority? And once that's the question is clearly comparative. The thing to keep in mind is that the question now becomes not whether we want something decided, but whom do we want it decided by? And so in particular, whether we want it decided by the court, or maybe courts, as the case may be, or by the legislature, or by parliament. So we're going to want to discuss, for instance, for any objection to judicial review, any reason showing why it's not a really good idea for courts to decide some of these issues, it's going to be important to see whether it's a better idea for parliament to decide them. And if not, perhaps we're stuck with an organ that's less than ideal, but still the best alternative. Similarly, of course, for arguments for judicial review. The question is always going to be, and sometimes explicitly, but even when not, it's going to be at least implicitly comparative. It's going to be about the comparative virtues of different institutions, different state organs. Okay, then, let's return to the worry we started with, namely the thought that there is something anti-democratic about judicial review. And let's try to precisify, to make that worry at least somewhat more precisely put now. Perhaps the thought should be something like the following. The main idea of democracy, again, not about the definition, the main reason why democracy matters is that the governed should also do the governing. And the people's sovereignty, at least in modern democracies, is mediated by the legislature, or by the legislative branch. So when the legislator has spoken, the people have spoken. What judicial review does, though, is to not allow the people to have its way, even though it has spoken in this way. So what you do if you allow for judicial review is you allow for a small number of judges to overturn the word of the legislature, namely to overturn the word of the people, thus allowing the minority to rule rather than the majority. Perhaps this is the problem that's often referred to in the context of discussions of judicial review as the counter-majoritarian difficulty. But it should be very clear that, thus stated, the worry is terribly oversimplified. All of this is just far too simple. We know that in modern democracies, the people speak, if they speak at all, via institutions. And I want to emphasize the if they speak at all, because I'm not sure that I'm happy with such locutions. They sound to me, at least often, metaphorical and at least somewhat often also politically dangerous. But to the extent that it's ever true that the people have spoken rather than that an election has been decided, if it's ever true that the people have spoken, then it's true because of the work of institutions. If the people speak at all, they speak via institutions. One way of viewing this is to talk about all the nitty-gritty details of how it is that the people purportedly speaks in a contemporary democracy. So we need to talk about rules of procedure. We need to talk about election laws. We need to talk, of course, about campaign financing and how they influence things. We need to talk about legislative procedures and perhaps about many other things of this kind. So it's not as if the people speaks in a loud, clear, and uniform voice. That's just not how it works. If the people makes a decision, they make a decision via a really complicated procedure that is subject to all of these factors. And I'm not even criticizing democracy just yet. This is to a large extent inevitable. But we should remember that it's not as if the people have spoken and then on the other side there's this small institution trying to make decision. The question, once again, is not whether the relevant authority is going to reside with the people or with an institution. The question is, once again, comparative as between different institutions. The only question is which institution it's going to be that's going to have the authority to decide the relevant question. And if you're not convinced of this, here's a thought experiment. You may think, imagine a case where a jurisdiction where there is judicial review. And now imagine the intricate kind of relation that exists between the court and parliament on cases that at least purportedly give rise to constitutional difficulties. Now think about that procedure. The procedure that includes as a part of the huge procedural black box also the intricate relations and interrelations between the court and the legislature. This is yet another procedural black box. There's nothing more significant about it than about the other procedural black boxes that we've already mentioned, things about election laws, things about campaign finance, and so on. So it's very natural to think of the procedure that also includes judicial review as yet another complication in your already complicated institutional legislative procedure. So once again, institutions are going to decide it. I don't know if you're happy talking about the people speaking, but if you are, you should acknowledge that the people will be speaking via institutional mediation of one kind or another. So if we're going to have such an institutional mediation already, why not the court? What are the legislature's advantages compared to the court vis-a-vis these issues? And I think it's safe to say that two advantages are at least usually mentioned. One is about accountability, and one is about representation. So very roughly, when it comes to the members of the legislature, they are at the very least accountable in the following way. Another election is just around the corner. So it's not clear how much you can influence your member of parliament or your congressman or your member of Knesset, but even if you can't influence him or her that much while they're in office, at least you can throw them out in a few years. When it comes to judges, this isn't always the case. It's not the case at least in the cases we're going to be discussing, namely cases in which judges are appointed for life. So in this respect, judges and so purportedly courts are less accountable than members of the legislature and so purportedly the legislature. This is about accountability. There is also the point about representation. So at least ideally you would think that Parliament represents the people better in a perhaps more inclusive, more comprehensive way than the court does. So let's spend some time on this way of understanding, or these ways of understanding the advantages of Parliament over court, or viewed in the other directions, reasons to suspect that maybe the court is not the right institution to decide the relevant matters. So we need to talk about accountability, we need to talk about representation, and we need to try and find out why it is that they matter, if indeed they do. Once again, though, we should bear in mind that matters are not quite as extreme as some political rhetoric sometimes make them sound. So even though judges are, or so we're assuming, appointed for life, it's not as if they're entirely insensitive to public opinion, say. In fact, this is a matter for empirical studies, and some empirical studies have been done on this, and it seems that courts are not far behind public opinion, even when compared to more run-of-the-mill politicians like members of the legislature. Perhaps, once again, what we need to do is to dig in deeper now. Perhaps we need to think about, again, the justification of democracy and majoritarianism and the relation, if there are any, to accountability and representation. Very well, then. Why endorse majoritarianism? Now, this is something that may sound as if it's obvious, but upon even just initial reflection, it's anything but obvious. Remember, the people you don't like at the grocery store, some of your colleagues whom you think are not remotely as intelligent as you are, or this sort of friend who is not as kind as they should be, and so on, they are the people. They are the people who will have the governing power. Many of them are ignorant in general or of the topic at hand. Some of them may not be the best intentioned either. And it's not clear that they should get to decide. And it's certainly not clear that the majority of those people should get to decide. This at the very least, calls for some substantive justification. And when I say substantive justification, one of the things that I have in mind is that definitions will not do. So saying something like, well, obviously majoritarianism is the way to go because majority rule is just a part of what democracy means, that would be unhelpful because we don't care about what words mean. And if we find out that democracy means something that's just not morally justified, then we can shift to another word, right? So definitions, once again, will not help. The important question is, why is it that we think, if indeed we do, that majority rule is important? And here, as I'm sure you can imagine, the literature contains much more than one possible answer, and we're not going to actually get into all of the possible answers. But I want to spend some time on what at least seems like a really initially powerful way of thought. And that's the thought that what majority rule does, what the rule one person, one vote does successfully, is to divide political power equally, which is something that we should do. So roughly the thought is political power is something good. It's good to have political power. And so what you want to do is to divide the political power pie between different people equally or roughly equally. And I think that at least in some contexts, and I'm not sure that it applies as well to the political context as we'll see, but at least in some contexts, I think that the thought that majority rule or a decision procedure according to majority rule does divide political power equally, I think that thought can be very, very intuitively appealing. So think about smaller contexts. Suppose there's a group of people and we need to decide which restaurant we're going to go to for dinner. There are many decision procedures we could contemplate, right? One would be to just use some arbitrary randomizing device. Another would be to just let me decide, or let you decide. Or we could go with, there are crazy options too, right? You could hear what my first option is and then go for the thing that's as far away from it as possible. There are many possible decision procedures. But I think it's hard to deny that there's at least one very strong normative consideration in favor of one person, one vote. And the thought is roughly, look, there's a group of people, we have different preferences when it comes to dinner, but your preferences are at least pro tanto as important as mine. They're not more important and they're not less important, and equally for any other person here. So we should have a decision procedure that recognizes this fact, maybe that even symbolizes this fact, the fact that our preferences are equally important, at least when other things are equal. And a good procedure for that would be one person, one vote. So you get your vote, I get my vote, every person in our group gets one vote. And then if there's a majority for going to that nice Italian place, then we should go for that nice Italian place because that's the decision that was accepted in a procedure that gave all of us an equal share, an equal part of the relevant political, small-scale political power. So this is, I think, the intuitive thought about one person, one vote, and the relation to the equality, to a distributive kind of consideration, equality in the distribution of political power. If so, any deviation from majority rule will be a violation of the equal distribution of political power. And so this should give you at least the initial thought about how there's a suspicion about judicial review. If you allow the court to overturn majority rule, if majority rule encompasses something about the equal distribution of political power, here's your problem with judicial review. It violates the equal distribution of political power. Now, as I said, I think that this is an important line of thought, and I also think that one person, one vote is a relevant moral consideration in many contexts, mostly in small number contexts, like the dinner decision problem that I described. But there's much more to be said here about this kind of argument once we have moved back to the scale of a contemporary state, the contemporary political state. One question that you can ask is whether one person, one vote, and in particular in our context, not allowing the court to interfere, no judicial review, and so the authority resides ultimately with the legislature, whether it does, in fact, distribute political power equally. In the dinner example, there was at least a plausible case to be made that that is exactly what happens when we go with one person, one vote. No one gets more of the political power pie than anyone else. But in the political case, that just does not seem right at all. One thing we could do is just to do some political science. Don't worry, I'm not gonna, but it's at least a good initial start, right? We can talk about facts, and we know something about how political power is usually divided in contemporary states, and equally is not a good description of what's going on. Some of us can buy campaign ads, and some of us cannot. This is a huge difference right there. Some of us are sufficiently witty, or perhaps sufficiently influential within academia, or perhaps sufficiently well educated to get an op-ed into a fairly influential newspaper or website. Some of us are not. That's a huge difference in political power. And there are other differences as well. So once we're not talking about a group of people going for dinner, but about a political entity deciding its course, the thought that one person, one vote equals an equal distribution of political power is just terribly naive. It flies in the face of the facts. In fact, that is so clear that it becomes now no longer clear whether allowing judicial review sets back the idea of an equal distribution of political power, or whether it actually gets us somewhat closer to an equal distribution of political power, or whether it's just entirely neither here nor there. Anyway, at this point, the equal distribution of political power does not survive as a strong consideration against judicial review. Also, the ideal of distributing political power equally, which is very attractive when we're talking about a restaurant choice, it's not clear that it's as attractive about any other context. So think about contexts in which someone's rights are involved. Perhaps, for instance, mine. In that case, it does not seem that the power to decide should be divided equally between all of the relevant people. If it's about my rights, it seems like I should get at least some extra say, right? You may think about it even in some variations on the restaurant case. What if, for instance, I have this serious ongoing conflict with the owner of that nice Italian place? Now you may think that I have a right not to be put in that situation in which I go to that restaurant. And if so, it's no longer clear that the right way to decide it is one person, one vote. We're going to return to this later on. There may be also other topics about which it just doesn't seem that one person, one vote, or more generally, the equal distribution of political power is a good idea. If that's so, then there are going to be cases for which the rationale, the underlying rationale for majority rule, that about equal distribution of political power, just fails to apply. Let me remind you that there may be other rationales as well. We're just not considering all of them right now. Okay. What is left of thoughts about representation after we already know that one person, one vote, and in particular, or more deeply, something about the equal distribution of political power does not do all the work? Well, you may think that it's really important for a deciding institution to represent those that it governs. But now we should ask both how is it that it should represent them, and also why, if at all, is it important that it should represent them. One thought here is epistemic. And when I say that it's epistemic, I mean it's about our ways to the truth, our ways of finding out what the relevant truths are. So you may think, for instance, that it's really important for an institution to represent the governed because you want to have a better, somehow more comprehensive view of the relevant facts. Think about academic committees. On some academic committees, you want to have a student representative. And it's not always clear why you would want to do that, but at least one possible rationale is because you want to have the kind of information, the kind of insight that will come from someone who is a student or who represents the student, right? So this is an epistemic kind of justification of representation. And once again, I think that sometimes it makes perfect sense. It's not clear, though, that it will be helpful here, as the thought that when it comes to these specific decisions, we want a more representative body like Parliament to call the shots, rather than a less representative one like the court. And at least one reason for that, one reason why it's not obvious that an epistemic justification of representation can help here, is that in order to have the epistemic payoffs of representations, it's not required that representation is present in each and every junction, or in each and every case you're making a decision. If you want to have the different points of views and the comprehensive or more comprehensive information that you get by including more people in the procedure, you need to include more people in the procedure. That doesn't mean that you need to include more people in each and every part of the procedure. And let me remind you that we're now thinking about the huge legislative black box that may or may not include judicial review. So it's possible to justify judicial review, namely letting a less representative body call at least some of the shots, while still reaping all of the payoffs of a more comprehensive kind of representative body by having the point of views of others a part of the black box in other areas, right? Not where you allow for judicial review. So it's not like I'm saying that this epistemic kind of justification of representation never works. I just think that to the extent that it does, it may be able to use it consistently with allowing for judicial review. You may think that there's something symbolic going on, and I don't. Whenever you say that something is symbolic, it sort of sounds like you are putting it down. I don't mean that at all. It's just important to acknowledge what role it can and cannot have. So you may think, for instance, that if you have a governing body that's representative, the very fact that it's representative symbolizes something important. Perhaps it symbolizes something about the equal moral status of the different people, including those governed and those doing the governing. And that seems like it's a possible way to go. There are going to be some problems with the thought about symbolism is doing all of the work here. But perhaps more importantly, the former point applies. So there are different ways of making sure that you get that symbolic payoff of generating the view according to which, or perhaps emphasizing the view, or expressing your commitment to the view of an equal moral status to those governed and those governing. And it's not clear that the only way to do that is to allow for representation at each and every point. So this consideration too is at the very least far from conclusive. You may think that there are some other ways in which representation matters, but I have to say that it's not exactly clear to me what they would be. It's important to keep in mind that representation is one thing and participation is another, and we want to distinguish between them at least somewhat clearly. One good way of doing it is to think about something like the following example, a hypothetical example. So we can think about a dictator, or perhaps a kind of dictatorial governing body that includes a few people, and we can assume that they are actually very successful in making decisions that represent people's preferences, principles, hypothetical choices, and so on, right? So the crucial thing, though, is that though they represent the people do not elect them, the people do not participate in the discussion, the people do not call the shots, they don't have any authority. But the governing body, whether it's a dictator or a governing dictatorial body, is representative. So with this kind of hypothetical example, what we have is a nice distinction between participation and representation. This kind of representative dictatorial body is representative, but is not participatory. It doesn't allow the people to participate. And now one thing that we could ask is, how happy are we with that kind of arrangement? And perhaps more particularly, to the extent that you care about democracy, are you satisfied now? Are you satisfied because, the people's voices, now it's not the people's voice, it's the people's voices, are represented in government. And the shots are being called roughly according to, or in a way that lines up nicely with the majority preferences, or maybe the preferences and principle of people in general, something along these lines. Well, it seems to me clear that you shouldn't be too happy with it from a democratic perspective. Because what you want is something like participation, or power, or authority. The crucial thing here is about who gets to call the shots, to participate in the discussion. But it's not just participate in the discussion. It's not a debate club. It's who gets to participate in the discussion with an eye to making the decision in a kind of authority, power-laden discussion, one that culminates in a decision. And with the hypothetical example of the representative dictatorial body, what you have is, although it's of course representative by stipulation, it's that body that calls the shots. Nothing about the people. The people have no direct influence. They don't have power. They don't have authority. So when we're talking about participation, what we want is what's lacking in this hypothetical example. And arguably, it's parliament, not the court. That's at least the primary locution of democratic participation. That's where you have representation, but now we know that it's not really representation that we care about, is it? It's more about participation. That's where different voices are heard with an eye to making decisions. Perhaps that's the crucial advantage of parliaments over courts. It's not about representation. It's not clearly that it's about accountability either, perhaps to an extent, but not mostly. It's primarily about participation. And so we get the following kind of objection. The problem with judicial review, or anyway one main problem with judicial review, is that it violates participation rights. People have the right to participate in a democracy. The way they do it is by engaging parliament in all sorts of ways. When the court strikes down a piece of legislation by parliament, what it does is to annul the product of democratic participation, thereby violating the public's participation rights. This is an argument that more than one person has made, but perhaps it's most famously made by Jeremy Waldron. That's Waldron right there. Now, I think that this argument, the argument about participation, actually has some weight, but I think that it should be contained, shall we say. And there are many points that you can raise here. Here's one. There's more than one way to participate. There's certainly more than one way to meaningfully participate. You may think, for instance, that petitioning the court, either yourself, if you happen to be, I don't know, a law student who's about to become a lawyer, but even if you're not, with the aid of the ACLU or some other kind of relevant NGO, petitioning the court may be seen not as a way of challenging democratic participation, but rather as a major way of exercising it, at least within systems that the black box of which contains something about judicial review. So it's not clear that engaging in judicial review should be seen as anything but more participation, perhaps a different kind of participation. Then on the other hand, and on the other side, and let me remind you, it's always a question, it's always a comparative question. We're doing institutional design here. We shouldn't have too idealized a view of what democratic participation looks like when we're talking about parliaments. So voting once every few years doesn't sound like a hugely important participatory practice, especially since we know that many millions of people don't do that, even when it doesn't take that much effort to do that. And also when we know that when you vote, you in all likelihood do not make a difference. Okay, maybe there's more than we could do, right? Like writing an op-ed, let me tell you, doesn't make that much of a difference either. And we can talk about other forms of participation by engaging parliament. I don't want to belittle them too much, but what I do want to do is to have in mind a realistic view of democratic participation vis-a-vis parliament and a realistic view of what's going on in courts, for instance, in constitutional cases, and see that it's not at all obvious that the participation that's involved in petitioning a court about a constitutional case is any less respectable or any less worthy of democratic respect than the kind of participation that's a part of normal politics and election for legislatures. So this is one worry. Even if we do think that there's an important right to participation, it's not clear what the best way of exercising it is, and in particular, it's not clear that judicial review is always antagonistic to it. Here's another worry. Assume for now that judicial review does indeed infringe on participatory rights. So I'm giving Waldron quite a bit of what he wants for free now. If so, then this is already a very strong consideration against judicial review. It's what we call a pro tanto consideration, right? It's a one piece of weight on the scales against judicial review. But we should, when you use the metaphor of scales and of weight, you should check what's going on the other scale as well. So what should we do when really strong considerations are actually in conflict here? There's the participatory right on one side, but then there can be really other important considerations, indeed other important rights on the other. What if the legislature legislates a violation of my rights or allows my rights to be infringed or violated? In such a case, you either let the legislation stand, respecting participatory rights, but allowing the violation of my, whatever it is, say, right to free speech. Or else what you do is you engage in judicial review, thereby protect my right to free speech, and perhaps pay a price in the participatory rights of the majority or perhaps of people in general. Well, if we're talking about different scales and different weights here, there is no general answer as to who wins. We should just try to weigh and balance the different relevant considerations. And it's possible that participatory rights are really important and that they're going to at least sometimes trump the other relevant considerations. That's indeed plausible. What's implausible is the thought that they will always triumph. No, sometimes other considerations will be at least as important. So perhaps in those cases, the other considerations actually trump participatory rights. Notice that all of this stands even if participatory rights are very important and so count initially against judicial review. At least one way to go here would be to say that the court should have the authority to review legislation when it restricts participation, when it sort of goes against the very participatory rights that are supposed to protect it to begin with. It's not clear how exactly to delineate such participatory rights. Surely my right to vote, right? So if this is your rationale against judicial review, you should at least allow judicial review of legislation that either prevents me from voting or perhaps that somehow takes away some of the weight of my vote because of zoning laws or things like that. Maybe also you should allow the court to intervene when it's about free speech, or at least when it's about free political speech, right? Because free political speech is both in itself a major form of democratic participation and also a really valuable tool for my ability to exercise my right to vote in a kind of an informed and intelligent way. So this is one way to go, to at least allow judicial review in the cases in which participation is at issue. But once you allow that, the question becomes, well, sure, participation is really important, and so the court should not intervene too easily. But on the other hand, when these are matters that curtail participation itself, the court should have the authority to review. But once you say that, you think, well, wait a second, participatory stuff is really important. It's not the only important thing, and it's not necessarily the most important thing. So if you want to allow for exceptions that allow the court the authority to judicially review legislation when it compromises participatory rights, maybe you should do the same when it compromises other important rights, and perhaps other important considerations as well. And so what we seem to get at this point is that even if we assume that participation is extremely important, and even if we now put to one side the worries about how much you participate in a democratic election and whether petitioning the court is itself a form of participation, even when I'm giving Waldron all of that, it still becomes entirely unclear what follows. Perhaps what follows is not that there shouldn't be any judicial review, but that the kind of judicial review we should have should be especially sensitive to participatory rights, free political speech, and perhaps other things that are of this kind or at least as important.